Hello. During this week's training, we will shift our focus to the Consumer Credit Protection Act. Specifically, we will focus on wage garnishments. The Consumer Credit Protection Act is administered by the Wage and Hour Division. It protects employees whose wages are garnished by limiting the amount that the employee's wages can be garnished during a given pay period. Beyond this, regardless of the number of garnishments the employee has or how much is being deducted, an employee cannot be terminated. This act applies to and protects all employees. In order to better understand how the act is protecting employees, it is important to understand what a wage garnishment is. A wage garnishment occurs when an employer has to withhold earnings from an employee's paycheck due to a court order or other legal document. Garnishments can come from various sources, including but not limited to the IRS, state, child support agencies, creditors, and bankruptcy courts. Now that we understand what a wage garnishment is, it is important to understand how employees with garnishments are specifically protected under the Consumer Credit Protection Act. The Act protects employees by limiting the amount of earnings that can be garnished in a given pay period. This amount is limited to the lesser of 25% of disposable earnings, or the amount by which disposable earnings are greater than 30 times the federal minimum wage, which is $7.25 per hour. Which leads us into what are disposable earnings. Disposable earnings are the gross amount minus legally required deductions. The amount of earnings remaining after these legally required deductions are taken. Legally required deductions include federal taxes, state taxes, Social Security, unemployment insurance, and state employee retirement. Now that you know what wage garnishments are and the basics to Consumer Credit Protection Act, what do you need to do as a leader as it pertains to wage garnishments? If you receive a garnishment for an employee or an inquiry of where paperwork goes, you should make sure that this information gets to Human Resources and to the payroll department. For the sake of privacy, you should try to keep the paperwork and the situation as confidential as possible. If you receive any questions regarding garnishments, you should direct those to Human Resources. And you should ensure that employees know that garnishments will be handled in the most professional and confidential manner as possible, and it won't have any impact on their job. In conclusion, as an employer, we will follow any guidelines that we are provided. We'll follow all legal paperwork in regards to garnishing an employee's wages, and will never exceed the amount that's legally allowed. We also want to ensure that our employees will not be retaliated against for having a garnishment. We know that garnishments can come from numerous sources, and we will withhold according to the paperwork. Wages are garnished from disposable earnings, which, as discussed, are gross minus necessary deductions. And it should be noted that on the company's part, there are no notices, record keeping, or reporting necessary for this act. If you have any questions, they should be directed to Human Resources. Otherwise, you should be educated on garnishments and the Consumer Credit Protection Act.